Hello again. Part 8, motion for reconsideration of Judge Allen's October 27th, 2009 order. 3. Did Mrs. Gray give Irene Perry notice that she should pay 1/3 of her monthly rent to her? Suggested answer, yes. Defendant/plaintiff gave Irene Perry numerous notices for the years to pay 1/3 of her monthly rent directly to Mrs. Gray. Reference number 1 supra for the examples of the notices. Number 4. Did the trial court err in assuming that Lewis Starkman Company and or Ingrid Johnson were agents of Patricia Jackson Gray when they were alleged to have told Irene Perry that she must pay all of her rent to Ingrid Johnson? Suggested answer, yes. At no time relevant did Lewis Starkman Company and or Ingrid Johnson have authority to speak for Patricia Gray. Therefore, if Lewis Starkman Company and or Ingrid Johnson told Miss Perry to pay Mrs. Gray's share of the rent to Ingrid Johnson, it was not with the approval of Mrs. Gray and does not eliminate Miss Perry's obligation to Mrs. Gray. In Gray v. Starkman et al., CCP, Philadelphia County, November term 2007, number 1728, at Environment 136 of the Third Amended Complaint, Mrs. Gray alleges that none of the defendants had a contract or Mrs. Gray's approval to charge her a management fee from 2004 through 2007 for the rental property where Irene Perry resided. The defendants are Lewis Starkman Company, Larry M. Starkman, Louis E. Lassoff, and Joseph Winger. A true and correct copy of the Third Amended Complaint is available on electronic docket at Gray v. Starkman et al., CCP, Philadelphia County, November term 2007, number 1728, and is incorporated herein as though fully set forth. Ingrid Johnson had no power to bind another co-tenant, Mrs. Gray in this case, to accept Miss Perry paying all of her monthly rent over the objections of Mrs. Gray. McKinley v. Peters, 3, Atlantic, 1st edition, 27, PA, 1886. The correspondence from Patricia Gray, exhibited supra, clearly set forth to Ingrid Johnson and Irene Perry that no other party was speaking for or on behalf of Mrs. Gray concerning Irene Perry's 1/3 share of the monthly rent to be paid to Patricia Gray. 5. Did the trial court err in granting plaintiff counterclaim defendant Irene Perry's motion for summary judgment based on res judicata and collateral estoppel? Suggested answer, yes. Plaintiff/defendant Perry on June 8, 2009 filed a motion for summary judgment arguing res judicata and collateral estoppel as the basis for granting her summary judgment. A true and correct copy of the motion is available on electronic docket at Perry v. Gray v. Starkman et al., CCP, Philadelphia County, January term 2009, number 2312, and is incorporated herein as though fully set forth. Defendant/plaintiff Patricia Jackson Gray filed an answer in opposition to the motion for summary judgment on June 22, 2009. A true and correct copy of the motion is available on electronic docket at Perry v. Gray v. Starkman et al., CCP, Philadelphia County, January term 2009, number 2312, and is incorporated herein as though fully set forth. Defendant/plaintiff Patricia Gray's argument inter alia was, application of res judicata requires the concurrence of four conditions between the present and prior actions. 1. Identity of issues. 2. Identity of causes of action. 3. Identity of parties or their privies. And 4. Identity of the quality or capacity of the parties suing or being sued. Yamala Trucking and Excavating Company versus Just Defend, 771, Atlantic 2nd edition, 782, Pinpoint 784, PA Super, 2001. See also Chada versus Chada, 756, Atlantic 2nd edition, 39. When the cause of action and the first and second actions are distinct, or even though related, are not so closely related that matters essential to recovery in the second action have been determined in the first action, the doctrine of res judicata does not apply. Perry claims identity of issues in the November 2007 lawsuit filed by Patricia Gray and the August 2007 claim against Ingrid Johnson. The action against Perry was an ejectment action and claim for rent. The action against Johnson, a co-tenant owner with Gray, was for rent payments she collected and did not give Mrs. Gray her share. The rental periods claimed in the two cases are different. There is no identity of issues. Ms. Perry has an outstanding petition to strike the default judgment that was entered against her in the November 2007 lawsuit. The doctrine of collateral estoppel, also known as claim preclusion, operates to prevent a question of law or issues of fact which has once been litigated and fully determined in a court of competent jurisdiction from being relitigated in a subsequent suit. Spisak versus Margolis Edelstein, 768, Atlantic 2nd edition, 874, Pinpoint at 876 and 877, PA Super, 2001, quoting Incalingo versus Maurer, 394, PA Super, 352, Pinpoint 356, second citation is at scratch that. The doctrine requires the satisfaction of four elements. Collateral estoppel applies when the issue decided in the prior adjudication was identical with the one presented in the latter action. There was a final judgment on the merits. The party against whom the plea is asserted was a party or in privy with a party to the prior adjudication, and the party against whom it is asserted has had a full and fair opportunity to litigate the issue in question in the prior adjudication, in reference to IULO 564, PA 205, second citation 766, Atlantic 2nd edition, 335, 2001, citing Safeguard Mutual Insurance Company versus Williams, 463, PA 567, second citation, 345, Atlantic 2nd edition, 664, 1975. In the instant matter, Ms. Perry is attempting to make a convoluted argument to support collateral estoppel and res judicata. Both arguments are terribly flawed. Simply speaking, Ms. Perry was very careful in avoiding discussion of the delinquent rental periods that reflect non-payment to Mrs. Gray. An examination of the lawsuits will show that not only were there different rental periods that Perry was sued for, there was no discovery in the November 2007 action due to a default judgment being entered against Perry.